Good afternoon. I'm going to try and keep this brief because I think you've had some good sessions, and as today is the last day, we want to round up on a good note. I've been asked to speak on the role of lawyers in real estate transactions, and I would say that there are three key areas of responsibilities for a lawyer. Every real estate transaction, I hope that if you're involved in any transaction, you will make sure that you use a lawyer to help you ensure that you avoid litigation or come across difficulties in closing that transaction. So the lawyer's role essentially will be to receive instructions and review documents, to conduct necessary searches, and to prepare and register documents for you. So typically a buyer or seller of a property will approach the lawyer and give instructions on the transaction, and then you will provide them with copies of the documents that could include a site plan to enable the lawyer to do whatever searches have to be done. So I'll talk about searches. The first search would be for the land use. A lot of people in entering into a real estate transaction, if you're not buying property, thank you. If you're not buying property and you're just buying land, it's very important for you to make sure that the land use is what is demarcated for by the planning authority. So if someone introduces you to land and you just go and buy it without being sure of what it is zoned for, you might end up buying land which has been zoned for a cemetery and find out that when it's time for you to develop it, you will not be able to develop it for that purpose. Generally, most lands are either zoned for residential purposes or for commercial purposes, in some cases for mixed use. But if you buy a property which is zoned for commercial purposes and you try to develop a residential property, the local town and country planning authorities can stop you from developing it. And you may have already spent quite a bit of money acquiring the land. So a lawyer's role would be to check to make sure that whatever purpose you've acquired the land for is consistent with what the planning scheme for the area is. The second search would be at the Lands Commission. Typically, there are three areas at the Lands Commission. There's the Public and Vested Lands Management Division, the Survey and Mapping Division, and the Land Registration Division. Typically at this stage, if you want to do a search, you will find out that you have to do 3 different searches at the Lands Commission. And that is a cumbersome process. Might take you about 2 weeks for you to get your search results. But thankfully, the Lands Commission is going through a digitization process and has indicated that very soon they will issue only one report, which will be a final report. This will be very useful because currently there are times when you do a search, you will find out that you have 2 or 3 different search results from the different departments or the different divisions within the Lands Commission. And that can be very confusing. A lot of work that we do in my law firm is for banks, and we have to give them a legal opinion because when people go to borrow money for mortgages, we have to confirm whether the title to the land or to the property is accurate. And when we have conflicting search reports, sometimes that can create a difficulty because we have some reports which are favorable to the potential mortgagor, and others which are not. So hopefully that will be resolved soon. Another area is to do a check with the court system. A lot of people don't usually do this. They just generally just go into a search at Lands Commission. But sometimes if you do a search at Lands Commission, you will not be able to ascertain whether or not the land or the property you intend to purchase is subject to litigation in court. So your lawyer should be able to check with the court system whether there's litigation in that area, or with respect to the land or property. But generally, you can also find out that there's litigation in certain areas. And so the lawyer should follow up with the legal system, go to the court registry. There are a lot of areas in Accra where people own properties but cannot register it. If you look at the land or the area which is called Atomic, the reason why it's called Atomic is because the land in that area belongs to the Ghana Atomic Agency. And even though the chiefs have been selling the land for several years and indicating that the land will be returned to them by the government, it's difficult for people to register it because the land still belongs to the Atomic Agency. And the same applies to CSIR. There's a pending litigation in respect of land, I'll say behind the area called American House in East Legon. It's a vast area, but all that land there is fully developed with a lot of houses, but people don't have documents on those properties because the land belongs to CSIR, and the case is still in court. And CSIR have probably won the case at the High Court level. It goes to Court of Appeal, Supreme Court. But, you know, there are potential difficulties that will come up, and you will not even be able to use your property as collateral because you don't have any title to it. So it's important for your lawyer to be able to advise you beyond just doing searches at the Lands Commission to tell you whether there's litigation on it. Indeed, a good lawyer will recommend to you that you also do some on-site checks. Sometimes in terms of paperwork, everything may turn out right. But when you go onto the land, you may face difficulties with land guards and so on and so forth. Or there could be a dispute between the person who's trying to sell you the land or the property and some other party, which may not be on the records of the Lands Commission. But if you go to most properties and you make inquiries from adjoining properties, you will all just go through around that property in that area, you may be able to pick up certain information which will help you in the acquisition of that property. And you may be warned that this particular land or property you want to buy, there are land guards who come there often, or there's some dispute on the land. And it's important for you to do that sort of check also, because if you just rely on the site plan and do a search, it may indicate that the person trying to alienate the land to you is the owner of the land. But with all property transactions, there are two key ingredients. You need to have title and possession. And so you may be able to ascertain the title, but when it comes to possession or going onto the land to develop it, you might face some difficulties. The lawyer will also be able to tell you if you need consent before you can sell or buy the land. Some lands require consent. For example, if the land belongs to the government, you need government to consent. You need to apply for consent before you can transfer the land. If the property belongs to the State Housing Corporation, for example, you may need consent from the state housing company. And if it's stool land or traditional council land, you may also require consent from the stool lands division of the Lands Commission, and so on and so forth. So your lawyer, by going through the paperwork, should be able to tell you that you will require consent before you can acquire title to the land. This is very important because sometimes acquiring consent can be expensive, and there could be certain obligations that the owner of the land or the seller of the land may have to fulfill before consent is given. For example, if there's outstanding ground rent which has to be paid and it's not paid, you may just negotiate and buy the land or the property, and then subsequently when you're trying to register it, you will find out that in applying for consent, you may be required to have the previous owner's unpaid ground rent taken care of, and that will require that you have funds to cover that if the previous owner is incapable of doing it at that stage. Your lawyer should be able to advise you in all of this so that when you are negotiating on the price and you're closing, if there are these additional costs, they are factored into the cost of the real estate transaction. So we take it that you've gone through all these checks, everything has gone right. Then now the lawyer's role would be to prepare the appropriate documentation to be signed by the respective parties to the real estate transaction, and then have those registered. So just to let you know that Ghana has a new Land Act 2020, Act 1036. Before that, all registrations were being done under the PNDC law 152, which is the Land Title Registration Act, and then also on the Land Registry Act of 1962, that's Act 122. Basically, PNDC law 152 covers registration areas, which are or districts which are the whole of Greater Accra, parts of Kumasi in the Ashanti region, parts of Awutu Senya district in the Central region. Those are land title registration areas. So the rest of the country, which is not covered by this, you would do the registration previously under the Land Registry Act, but now we have a new act which covers land administration. So in conclusion, I would say that it's very important for you to use the services of a lawyer. As much as possible, you should try and get a lawyer who has experience also in real estate and land matters, because just like doctors, lawyers often specialize in certain areas. And so don't just go to a lawyer because he's a lawyer. Try to get a lawyer who has experience in real estate matters so that they can give you the required advice and help you to do all the searches. A lot of, I'll say, probably about 70 or 80% of the cases in court are related to land matters. And the reason is because very often parties to real estate transactions want to avoid paying legal fees and try to do the transaction among themselves, and don't do all the searches, don't do all the checks. Or sometimes when they do these searches and checks and the results are unfavorable, they still choose to go ahead and do the transaction, only to face these challenges later on. And your lawyer should be able to help you to avoid finding yourself in a situation where you end up in litigation which can be drawn out for a long time. and give you the right advice, help you to get the right documentation, get it fully registered. A lot of people get documents, indentures, and so on and so forth, but don't even register it. And then later on, there are challenges, especially where in some cases where the person passes away, or someone, even though you have the documentation, because it's not registered, someone else goes to conduct a search, and there's no record of the fact that you've acquired the property, and they now go and find a way to get documentation and register it. So there are people who have properties that they've lived in for several years, but if you conduct a search, you will see that the ownership or the title is in the name of some other party. And all of this can be avoided if you use the services of a lawyer who helps you to have your documents registered appropriately. So thank you very much. I'm sure that you may have some questions, or you may have your own challenges. I might be able to give you some free legal advice on Friday afternoon. But for Monday, I'll charge. So, yeah, please. Okay, thank you very much. Well, I'm sure that to get possession of land, you must have made some payment, because nobody would just allow you to go into possession of their land. So I will assume that you've made part payment and then you're allowed to take possession of the land. That's a good step, because obviously, even if there's a court case in the future, the fact that you're able to have possession of the land may inure to your benefit. In fact, there's a law on adverse possession, where if you've been on a land for an excess of 12 years, it gives you an interest in the land, and potentially can give you title to the land. So possession is definitely something that is very important. And if you can make a part payment and then go into possession, then of course that's a benefit to you. But if you have possession and you don't have title on the land, it means that in the future, if somebody is able to obtain and register and get title to the land, they can go to court and get an order to remove you from the land. Or if you haven't developed the land, then they will come now and take over possession. And if they go to court, or it's even reported to the police, as sometimes happens, then they will have a better story than yours, and they will be able to prove a better interest or title to the land than you have. So it's important to make sure that whoever you're paying that money to and who is allowing you to get possession of the land is recognized as the party that can sell the land to you. Because if that party that you're paying to is not on the records as the owner of the land or the property, okay, and you make a part payment and you take possession, and the one who is on the records as the owner of the property now comes, and they may be able to obtain an order to remove you, and then you have a difficulty because you've made part payment, or maybe even made full payment for the land, but then now you have a challenge because you don't have any title documents to the land. You know, and this is the situation that a lot of people face. You know, they are shown a piece of land, okay, they don't do the searches, they quickly make a part payment, or sometimes make full payment when the land is not that expensive, okay, and then later on now want to regularize it by now bringing the documents to the lawyer to now do the searches and everything, or say they bring you the documentation and say, go and register it for me. Then you bring me the documentation. First thing I'll do is I'll go and do a search, and then I'll tell you that according to the records this land belongs to Ghana Agric Cattle Limited, and it's for farm stock, for cattle rearing. But if you go on the ground, you will see that the entire area is developed, posh houses, and you will see that that whole area, nobody has any documents, and you will see sometimes you even have some lawyers and judges and politicians living in the area, but they don't have any documents. And you seeing that development would just say, okay, let me just, pay and I'll take possession, go in there. And then you bring me the documents. I can't register it for you. And then now you have, difficulties in trying to get title to the land. And if it's not even such a grantor, if it's in someone else's name, and subsequently that person goes to register their title, or they transfer it to someone else, and that person goes to register their title to the land, they will go to court and get an order. And if you're not careful, even the property that you have on it, if you are able to develop it, it can be demolished by court order. There's a popular myth that if you build to the lentil level, you are safe. It's contained in what's called Act 2, which was passed during Nkrumah's time. Now, for you to be able to benefit from that, you must show that you are a bona fide purchase for value without notice of any defect in the title. This means that you would have had to go and conduct searches, and you must not have known that there was any dispute on the land. You should have done your research, done everything, started building on it, and you must bring facts to show that you took all the steps that you could take to ensure that you had good title to the land. And for some reason, you are now being deprived of that benefit of the land. But if you know that, or there was a dispute on the land, and especially in a situation where you are building in the middle of the night and all of that, then everyone or the court will be able to establish that you knew that there was a defect in the title, and therefore, by virtue of building to lentil level, you cannot be covered by the law. So this is the situation. Yeah. I'll take lady and then you next. Yeah. Yes.
They would say what they have is indenture, and you would find most people have an indenture as against real certificates and real title certificates. My question is, what is the value of indenture really? One is prepared by the seller and to other people. Except it's really registered at the court, but in proving title, especially at the Lands Commission, what role does the indenture play? And in most transactions whereby they show you that, okay, there's indenture and they're passing off the title to another person altogether, is that really of much value? Is that document of much value? Thank you.
Okay, good. So the reason why PNDC Law 152 was passed was because they wanted to establish title to land. Before PNDC Law 152 was passed, the previous Land Registry Act only allowed you to register your interest in land. So basically, in respect of one piece of land, there could be multiple registration. And therefore, because the lawmakers recognized that it didn't establish title to land, that the PNDC Law 152 was passed. So ultimately, if you're buying land or property, you want to buy land or property that has a land title certificate on it. But bear in mind, like I said, it has to be in a registration district, which is Greater Accra, parts of Kumasi, parts of Awutu Senya, and so on and so forth. So for purposes of your question, I'm assuming that this is Greater Accra, and that there's an opportunity to obtain a land title certificate. So ideally, you should only buy a property that has a land title certificate. But because not everyone has one, then you could purchase, if there's an indenture, okay, covering it. Now, the indenture will only, or should ideally be plotted. So it's plotted at the Lands Commission. So if it's plotted at the Lands Commission, if you do a search on it, you will see that this person who you're buying from has their name on the records as the owner of the land. Now, if you do a search and that name doesn't come up, then you know that you're buying from the wrong person. So if you ask the seller for them to give you documents and the name on the document says Kojo Mensah, if you go and do a search, then Kojo Mensah's name must appear on the search as the owner of the property. If it's a different name that comes up, then you know you're going to have challenges. Of course, you must also go a further step to make sure that Kojo Mensah, as appears on the records, is the same Kojo Mensah that you're buying from. Because in practical terms, there are people who can pretend to be someone else, and you end up paying to that person only to find out that you've paid to the wrong person. So if you're buying and it's not a land title certificate, you can still use an indenture if you're buying from the right person. It just means that you will need to go and do what is called the first registration. It means you will become the first owner of a land title certificate in respect of that area. Of course, that process of obtaining a land title certificate involves a publication. So it will be published in the papers that you have applied for a land title certificate in respect of the property or the land that you're buying. And that process allows anyone to caveat. If someone has an interest in that land, they can caveat your registration. So it's a risk that you take, that in the course of your registration, another party may come up and say that they are the owner of the land. But if you don't have that challenge, then hopefully you'll be able to complete the registration into your name. I heard the gentleman from JIPC say that you can register in 46 days. And I was very surprised because the shortest period that I know that you can register is probably about 6 months in Ghana for you to obtain a land title certificate. And that's, because they always ask you for some other documentation. Sometimes they may even ask you for previous documents or even judgments that are in the recitals. And you, the person trying to register it, you have to go and look for it and bring it. And it's a big challenge. So in practical terms, you will have those challenges. So to summarize my answer, yes, if the seller gives you documents, you should go and do a search. But even then, I will advise that don't rely on the seller's documents alone. It's advisable for you to prepare your own site plan, because the seller may give you a document that has a site plan for some other property that they own, which may not be the particular property they're selling to you. So as much as possible, if you have the opportunity to buy a property, get your own surveyor, go onto the site, draw up the site plan of the exact property that you intend to purchase, and conduct your search using that site plan. Then you're sure that that site plan is actually an accurate and correct depiction of the property or the land that you intend to purchase. This is added layer of security to try to avoid finding yourself in difficulty. Yeah.
Okay,
Yes.
sir.
Oh, sorry. He had raised his hand before. So, yeah.
So my name is Samuel. I'm from the Oti region.
Okay.
And there is a trend. Most of the landowners don't have any title or any document. But if you want to do a search, Lands Commission tells you that go and do a site plan. So it means that you are already paying money, paying a licensed surveyor before you can even do the search. So now if you do the search and you realize that the plot is maybe a government land, then it means you have just lost spending. So I want to know, is that the right trend? Thank you.
Good. No, that's not the right trend. And unfortunately, those are some of the challenges that we have, which also cascade and affect our ability to even give mortgages in this country, as the previous speaker said, because our land tenure system, okay, and land ownership system is fraught with so many difficulties. If you go into a developed country, the property belongs, to ascertain the title, you can literally go online and find out who owns the land. And I think that in our history, we lost the opportunity to acquire. I would have said that the government should have acquired all of the land, okay, and registered it to make it easy to ascertain ownership, and in where it was possible to pay royalties to chiefs and so on and so forth. Our current system means that there are different types of ownership of land. There are some lands that are owned, very few, by the government, but then you have chiefs, you have families, okay, you have individuals, and sometimes even within the families, there are different types of owners within the families and so on and so forth. So no, it's not the ideal situation for you to have to incur those costs to ascertain who the owner of a land is. But unfortunately, we find ourselves in a situation where determining who the owner of a land is still a challenge. And until we're able to get to a point where that becomes easier to ascertain, we'll have those challenges. The cost of registration, but there's a land reform project going on, and hopefully it will help, to reduce these challenges. But the truth of the matter is that until then, you have to take a risk and incur the cost of trying to ascertain who the owner of the land is. But I'll say it's a small cost compared to not doing those checks and then making a payment for the land or the property, only to find out that you've paid to the wrong person and lost significantly more money than you intended to. Sure.
Hello, thank you very much. My name is Redeemer of Lacrosse. My question has to do with the lawyer and the surveyor. I believe that these processes are all part of the due diligence we take when we want to ascertain who the rightful owner of the property or the land might be. All along during your presentation, I was hearing the lawyer does the searches and blah, blah, blah. Sorry. I've known the surveyor. The latter part after Abner asked her question, I realized you came with the surveyor. I know we come with a site plan. As part of the due diligence, the site plan must be provided. The markings must be done. And I know it's the surveyor who does all these things. And I've known the surveyor to be also following up with the searches from the Lands Commission here and there. Now that you're speaking from the legal aspect, which is the right procedure to follow? Could it be the surveyor who must do the follow-ups at the Lands Commission, or it must be the lawyer? Because I've known the lawyer to come in when it comes to the transfers or the conveyance. Now I'm hearing that the lawyer must do the searches also. So this is my question. I need clarification, sir.
Okay, thank you very much. Okay, so a surveyor's work is essentially to prepare the site plans for you. That's all they're supposed to do. If you engage them to do additional work for you, that's your own cost or whatever. You would only be using their services as an independent person. But their point is, a surveyor's job is to prepare site plans. It's the lawyer who has to ascertain and do the due diligence to be able to determine if who has title to the property or to the land. Some people obviously use surveyors and other agents in the lands commission system and all of that, which you're free to do so. But under our laws, for example, any documentation that has to be prepared by a lawyer. A lawyer has professional responsibility. If they don't do what they're supposed to do, okay, there are ways to address that, you know, professional negligence and so on and so forth. Maybe I should use the example of maybe a doctor and a nurse. It will help you. So if you're not, you know, feeling well, or if you need medical attention, you're actually supposed to see the doctor. The nurse has a role to play, but their role is not the same as a doctor. So the surveyor's role is not the same as a lawyer's. It's essentially to draw up site plans for you. And then the lawyer has to take over and make sure that they're able to ascertain that this title is correct. And a lawyer has professional responsibility. If they give you a legal opinion, for example, that says that the title belongs to party A, and subsequently you find out that it didn't belong to party A and belonged to party B, then they are being professionally negligent. They have a code of ethics, and they could be liable potentially to disciplinary action for acting negligently. So you're safer dealing with a lawyer. Sure. I think we have all the questions now. Thank you very much for this one last one here. Yes.
I'm Linda from AA Africa. I wanted to find out, to find ownership for a particular property, aside the searches, as in at the Lands Commission and at the court, are there other ways to find out the ownership?
Okay. Thank you. That's a good question. Like I said before, you will check with, say, for the use of the land with town and country planning, you will check at Lands Commission for title and ownership of the land. On-site checks, I think I mentioned that briefly, sometimes is important, especially when it's land. This is just practical advice that you probably go and buy 1 or 2 heaps of sand and stones and place it on the land to see if someone else may come and try to claim ownership. Those are, and then also making inquiries in the neighborhood or asking the owners of the adjoining properties if they know who the owner of that particular land or property that you want to buy are. I'll say they're just additional checks that you can conduct to be sure. But essentially, once you do those checks at Lands Commission, that forms the key due diligence that you have to do. And then you want to be sure that whoever the search reports indicates as the owner of the land is actually the person that you're dealing with, so that you avoid litigation or running into difficulties later. Yeah. Okay. Thank you very much for your time, and all the best.